of Frauds legislation operates in some form in all Australian states and territories, which affects contracts for the sale of an interest in land and goods. True, false? Let's find out if you were listening. True or false? Get a couple more in. Ooh. Really? Oh, Catherine. Okay. Really? Oh, yeah. So why?
It doesn't affect goods.
Not goods. Okay? Reading the question. Alright, so the statute of fraud legislation operates and it affects the sale of an interest in land.
Yeah, I know.
You guys just got smarter and smarter. Like the value I add to your lives. Just feel so good about it. Okay, here we go. When it goes all black like that, it freaks me out. Okay, what's the difference between a guarantee and an indemnity? I should have actually done this first to see if you... Okay, now I'm going to find out how well I explained that. Your options are: guarantee involves a primary obligation, whereas an indemnity involves a secondary obligation to keep a person from harm. A guarantee will not exist without a debtor's obligations, where an indemnity can. An indemnity will no longer exist if the debtor's obligation no longer exists, where a guarantee will, or the terms are interchangeable. Sorry. I am so hungry by this point. It's like I'm very food motivated. I find myself walking over and looking at people's food. So it's really sad. No, I can't. I really can't. Oh, I really like those two. But I can't. But imagine, at least the good thing with this recording on the floor is that I wouldn't be crunching. But here we go. 13. Okay, show results. Just do that. Oh. Come on. So let me try and get my head around. So a guarantee does involve a primary obligation, but the primary, that use of primary obliger, I think, is what's confusing. The primary obliger is the person who has the primary obligation. So in the examples that I gave before, I owed money to the bank. So I have a primary obligation to repay the loan. Robin owes money to the bank. She has a primary obligation to the bank. But the guarantor has only promised that the primary, that they will fill in if the person with the primary obligation doesn't do what they're obliged to do. And so if the primary obliger actually has no obligations, the guarantor has no obligations either. Where an indemnity is a primary obligation to the bank itself. I am holding you from harm. Alright, which of the following will the courts consider in order to determine if a document has satisfied the statute of frauds? Now, I haven't spoken about this stuff yet. This is the prep stuff. You can select more than one if you wish. So, does it look at the detail contained within the document? Does it look at whether the parties are named in a document? if a number of documents can be read together to constitute a note or a memorandum, or the number of documents that form the note or memorandum. So again, why don't you, instead of just going, and because we didn't talk about this, talk to the people in your table and come up with a view as to what the question is actually asking you to do first. Why is this even a question? Take everything from a Victorian perspective. But quite frankly, with a broad question like this about the statute of frauds, it's really asking what has the common law done to make sense of this? So how does it work out whether something is a document or is in writing for the purposes of a statute of fraud? Well, there's a few people have been brave. Let's see what everybody's putting in at the moment. Let's see, and oh no, that's not what I want to do. Oh, sorry. I just want to. Why is that not sticking? I said that. No. Okay, that's interesting. Very interesting. May you live in interesting times. It's getting more interesting. So let's just think about what this question means. So what we're really asking here is, as courts have been working out whether the writing is the kind of writing that satisfies the provision, what I'm really asking there is, the law says you can't sue somebody on a guarantee or an agreement relating to land unless that agreement or guarantee is in writing, signed by the person who we're going to sue. So how do we work out whether a thing is sufficient for that purpose? So there are two ideas there. One is it can be an agreement in writing, ACE, or it can be a memorandum or note of the agreement. And the cases have looked at a range of different kinds of things. I heard Sue over here before mention joinder. Ring any bells? Love a good joinder, I'm hearing over here. Who doesn't love a good joinder? It's like, oh, I'm sorry, now my brain's going thinking, oh, I could write a question here that, based on those stoner movies of the 80s, but Cheech and Chong and the statute of frauds. I'm seeing a way of going there, like, you know, challenge accepted. So this is the question. What is it that is sufficient to be writing? So I'm thinking of a continuum here. One end of the continuum is an 80-page document with the names of all of the parties at the beginning and some definition provisions and signature pages at the end and maybe a couple of annexures with plans and a whole lot of detail in it, stamped with the name of a prodigious law firm, or prestigious law firm I should say, on the front cover. That is likely to be sufficient writing. Take my word for it. Couple of post-it notes and a napkin with a beer stain on it that says Elliot agrees to spec out the boat and be Vice Chancellor. Kath agrees to be the primary borrower as long as she doesn't actually have to come to class. The non-wearing of heels is an essential term. That's on a separate post-it note though, and then there's the napkin that says, and we're going to do it on a boat. The whole university will be on a boat. Would that be sufficient?
like to think so.
You would like to see. So what would we be looking at? So then we've got
Detail in the napkin.
So we're looking at detail on the napkin.
So if it's a clean napkin.
Trust the doctors to want to involve the hygiene factors. It doesn't matter whether it's a clean napkin. Does the napkin have to be written on for this purpose exclusively? Could it have been used to wipe up rice cracker crumbs first? Does it matter? So what kind of things is a court looking at to work out whether or not writing is sufficient? So my giveaway to you is something that looks like a binding legal agreement signed by both of the parties with definition sections and headings and a table of contents that somebody spent a lot of money on with a law firm. Pretty likely to, not always mind you, law firms get it wrong all the time, but pretty likely to help us get across the line. So on the other end of the continuum though, memorandum or note of agreement. What does that mean? What's the court looking at? Might be more than one of those things. So detail?
Yep.
You think it'll look to the detail? Does it matter whether the parties are named in the document or not?
Yeah.
Courts will look at that. Does it matter if there is more than one piece of paper, separate piece? The number of documents can be read together to constitute a note or memorandum. Will the court look at that?
Yeah.
Okay, but then the most popular one you have is the number of documents that form the note or a memorandum. Like, what number is that?
6.
6. If you're not confident, sound confident about this, alright? Absolutely. I've been doing it for 5 years since I teach this class. I just sound confident. You know, actually, before this, I cleaned toilets. Well, anyway, sorry. I was about to say I was a financial planner, but that was really rude. And then I said it out loud anyway. Oh, terrible. By the way, you do have to do course experience surveys soon. Probably better if you don't do it after I insult you all. Okay, the number of documents to form. This doesn't mean anything. The number doesn't matter. So I mentioned joined before.
We have 6 napkins.
You can have 6 napkins if you wish. It could be 1 napkin if it has everything that needs to be done. It could be 1 napkin, 2 post-it notes, a letter, a couple of emails and a text message. It really, really doesn't matter. Maybe some graffiti on the back of a toilet door if you need it to be. As long as it's joined together in the right way. Sorry? It could be anything. It really could be anything. So it could be Facebook posts. It's as long as it's writing. But again, thinking seriously for a minute, if I've got something scrawled on a toilet roll, something on a napkin, and a Facebook post, what do I need to see to bring them together to be the number of documents that can be read together? Is it just enough that I was the author of all of those things? Okay, does that mean I need the other party to be the author of some of them? No. What do I need?
They have to all be linked.
They have to be linked. So what does linking mean?
So maybe referring to.
So they might refer to each other, they might be stapled together. It might be a Facebook post with a photograph of said napkin and toilet roll that says, Elliot's posted that on Facebook. He said, we made a deal. We've got the beginnings of, what are we calling our university? Do we have a name yet?
RMIT2.
RMIT2, sponsored by Lexi 2.0 Becky. We've got a deal. He's got photos of all of the terms, and I've come and given it the classic thumbs up. Maybe I've even given it the heart. Okay, like on the heart. And you guys have come in and you've given it the wow face, right? Like it's all there. But we've got a symbol that means, from the other party, we've got enough of that information all in one place. It's joined together. Okay, I'm not suggesting, by the way, you enter into contracts like that. Firstly, you guys want jobs at the end of this. It would be better if we did it the normal way. And the uncertainty and other issues are there. But if we have some way of linking them together, the courts are looking for an agreement. Courts are looking for an agreement. Questions? Oh, sorry, let me just hit the button that shows you what's correct and what's incorrect. Number was your
There was
first
something
thing.
in the reading that said the parties, I don't know whether this was the same thing, but the parties didn't necessarily have to be named as long as they were,
Okay. Oh, now don't think that all of these things have to happen.
Right.
They're just things that the courts would look at.
Okay.
So yes, well, who the parties are will almost always be an essential term.
Yeah.
But you might not necessarily get their full and correct names, or you might have some other way of dealing with it. Like, so, you know, in future contracts I have with Lexi, this Lexi will be Lexi 2.0, this is Lexi 1.0. Because I do think they were the same person on email for a little while. So now I've got them separated, it's okay, but yeah, so they're the name. So if I were to use those names, that would be enough, I hope, for us to understand who I was talking to. So if I sent out an announcement to the rest of the group and said, you know, I don't think I can, well, Lexi 1.0 is from the other class. She's from OUA. So I sent a group to you and say, okay, we're all going for a beer on our last day. Please let Lexi 1.0 and Sue know. Now, do I have anybody else from OUA who I'm ignoring now? I don't think so, but we'd let you know, you in the little people in the recorder as well, but just let these guys know. You would know what that meant. And you would be in breach of your contract with me if you didn't, if we had the other elements of the contract there. You understand what I'm just going. Just let's just move on, Kat. Move on.
Do you have a recent example of a case where something like that's been come up on the internet or something like that?
There have been many disputes. There's been a number of examples where the police have used Facebook and dating websites to identify people. There is a case about 2 years ago, I think. Is it Russell and Lowe? Where there were a string of emails that became that together were pulled together. But I can take that under. Can you send me an email and I'll actually look up for something that, because that might be a good problem to research when we do the Research Ninja class. This one should be quick, I hope. No physical connection between two documents, then there's no way in which the documents can be joined in order to satisfy the legislative requirements. True or false? If there hasn't been a physical connection between two documents, then there's no way that they can be joined. True, false? Oh. Absolutely. Okay, so we've just spoken about that. So, somebody's. Which of the following statements best describes the authenticated signature fiction? So, we haven't spoken about this earlier. You will remember that a big part of our discussion in relation to section 126 was around whether or not the documents had been signed. So the authenticated signature fiction, I will give you the clue, goes to the question of whether or not that requirement for signature has in fact been met. So, one, the relevant document contains the name of one of the parties and that document has been identified as a final agreement. Both parties have signed the document. The party to be charged has signed the document and the document has been identified as the final agreement. Or the relevant document contains the name of the party to be charged and that document has been identified as the final agreement. I'm not sure this is a very helpful question actually. It's just giving me my 8:15 alarm, so if I go past 8:30, wave me down. Right, let's see. Okay, so both parties have signed the document. If both parties have signed the document, we don't have a fiction. So we have both parties have signed the document. So the authenticated signature fiction is a legal rule that has developed to address the problem of when a document hasn't been signed. Remember, 1677, your average person who could enter into a contract probably couldn't read. So signatures, we don't have a high bar for signatures at the law. We have, the question is a mark or something that has been, that identifies a person as being the individual. So the party to be charged has signed the document and the document has been identified as the final agreement, or the relevant document contains the name of the party to be charged and that has been identified as the final agreement. I'm going to see what I put in is correct so I can think about what I'm doing. So what's important is that the person who is going to be sued, that they are named in that document and that there is no dispute as to whether or not that is the final version of the agreement that was reached or contains the terms that were the final, records the final terms. I'm hoping that I get, if I get the question I want next, no, I'm sorry, I'm going to flick through to the question that I want just because I want to make sure a point gets explained. No. Sorry. Why does this do this? No, I mustn't put the question in there. All right, let me start. So with a memorandum or note of agreement, if we can have a written agreement or we can have a memorandum or note of agreement that satisfies the statute. When does the memorandum or note of agreement need to be created? Before the agreement is created, or after the agreement is created, or contemporaneously with the creation of the agreement?
After.
After? We've got a vote for after here. Contemporaneously over here. We've got a couple for there. Anybody else? The rest of you are like, yeah, whatever you like. I didn't hear what that was.
Yes, probably good.
I might be rethinking that disciplinary policy in our university. Thoughts? All right. Has any guesses? Let's do it logically. So tell me why you think it needs to be contemporaneously, and what that looks like in effect.
So you can't do it before because you obviously haven't come to an agreement. It can be afterwards, but then how soon afterwards? So that's why I went for contemporaneously, because that gives you a window of time, and I believe that would look like perhaps a few documents going back and forth, or a single document that occurs at the time of agreement.
So how is that not a written agreement then? How is that different? If we're talking about a memorandum or note of agreement, and maybe that's a better question to ask you to start off with, and I won't leave it all with Sue, but what's the difference between a memorandum or note of agreement and an agreement? So think of Peary and Saunders if you need a case reminder. Okay, I'm going to ask, Lexi 2.0 was very certain about her answer. And will it help me to tell you that you're right? Will it help you if I tell you that you're right? Then explain what your thinking is.
And normally just it's in addition to whatever the agreement that has already been formed, and people wish to add in extra lines in there, but it's not literally binding both of the parties. It's just extra.
All right, so you're actually thinking about an addendum to an agreement or a memorandum or note. So when you've got a standard agreement that has been reached and probably in writing in the context that you're thinking about it, and then, so a good example, it's not really an agreement example, but a good example is many solicitors will say, if you're writing a will, let's get the base stuff in the will, but why don't you just keep a note with your copy of the will about who you'd like to leave the jewellery to, or your shoes, or the Tupperware, or not the big stuff, because it's much easier if you change your mind about that to go and screw that up and throw it away. You're thinking about the note or the addendum in that sort of context, aren't you? So I'm talking here about a memorandum or note of agreement in the context of section 126, where the options were we have a written agreement, or we can have a memorandum or note of agreement. So Peary and Saunders is a good example of this. So in Peary and Saunders, there was they wanted to lease a space for a bakery, and it's a South Australian case, and so I think it was the landlord solicitor came in and made a set of bullet point notes. It included things like what the rent would be, who would be responsible for the fit out, what the premises would be used for, those kinds of things. There was no formal written agreement ever entered into. And then subsequently, the question became whether that note that was made by the solicitor could be a memorandum or note of the agreement of the parties.
So you're saying no because it's contemporaneous?
Well, in fact, in that case, it would have been made prior to the agreement being finalised, or as part of the agreement being finalised. But yeah, the courts found no, that it couldn't be, partly because it was made prior, partly because it wasn't sufficiently certain. It was written in a way using the Masters and Cameron analogy that we spoke about 2 weeks ago, that it contemplated that it would be replaced by a final agreement. But effectively, for a memorandum or note of agreement to be effective, it needs to record what the parties' agreement was after the agreement was made, but before the action is brought in the court. So it doesn't need, I don't think contemporaneous actually makes a great deal of sense. It would actually just be a written agreement in that context. Might be a faulty written agreement, but if the agreement is in writing at the point of time it's made, it's probably the act of signing that makes it. It would either be immediately before or immediately afterwards. But in the case of a memorandum or note of agreement, it needs to be a memorandum or note that's made about the agreement that's already made. So, because in order for an agreement to be made, we need to have agreement made up of offer and acceptance, or a meeting of the minds, consideration, intention and certainty. And so when we have all of those, we have an agreement. If it relates to subject matter that needs to be put into writing, then subsequently you can say, well, we made that agreement last week in relation to the buying of that yacht for our university. We didn't write it down. And so we tell our solicitor Grace here about that, and she says, well, actually, I think there's some formality requirements in relation to boats. So I'll make a memorandum or note of the agreement. The two of you can look at it and confirm that that is what you have in fact agreed by signing it. And then in 10 years' time, when we have a fight about it, because I can't imagine anything going wrong for at least the first 10 years, at that point we will have on file our memorandum or note. Sue?
So then how does that work when there's all these different documents that then make up the note?
Okay, let's ask, that's a really good question. So what happens when we've got a whole lot of documents? Do they make up the note or do they make up the agreement?
You gotta filter through it, don't you?
Yeah, and it will depend. So if we've got the example that I gave earlier where we've got something on toilet roll, a couple of napkins, some post-it notes, and a Facebook post, presumably that all gets gathered together at some point, and we agree with our different bits and pieces. Yes, it's agreed. That adding it to Facebook post, if the actual post we've reached agreement, and we had in fact shook hands on it earlier than that, it may in fact be a subsequent note because both of us are acknowledging it. But it really just depends on what the timing is. Which is it? You go through each of the documents and work out, does this lead up to our agreement? Because particularly if we've got things have been scribbled out, I give you a post-it note that says something, and you send me back an email and say there's no way I'm going to give up on that. We go backwards and forwards.
It's relatively final, is that what you're saying?
Yeah, oh, well, in order to be an agreement, it does need to be final. It needs to be certain. It needs to be certain, which means it needs to be complete, it needs to be not illusory, and it needs to have sufficient certainty. And once we reach agreement, if it's not written down at that point, we can still write it down afterwards, but you cannot sue somebody on it unless and until it's written down and signed by that person you're going to sue. Or the authenticated signature fiction will help us identify at what point we've got to. Right, we've got 3 minutes to go, so I think this is where I finish up. It's not overly complex, this stuff, but you do need to work through each of the rules. So there are little videos. From memory, I think there's only one lot of videos for next week. That part of it isn't there. I have been told, reliably informed, that there is a missing set of PowerPoints. I'll fix that up. Questions, concerns, otherwise come and see me or after class or send me an email. Have a good week, people.